Hello, everyone. Welcome to the Empower series. My name is Clifton Johnson, and you are in to be empowered. So I'm not going to take a lot of time doing the intro like I used to, because I'm going to get our speaker up immediately, because you came here to know how to acquire peace of mind and create a legacy of love and go through your estate planning checkoff list. Because if you're like most people, you've been putting it off and putting it off. So with that being said, let me just tell you that all of the links to the handouts and the documentation that our speaker will be going through is underneath the video. So you should have AARP lesson book, and you should have the AARP record book. There's a pre-assignment where we want you to go through this at first. If you didn't go through it, that's all right. But you'll also have a link to the PowerPoint presentation that our presenter is going to go through today. And I also created an action plan guide at the very end. So like I said before, all of those links are underneath the video. So let me just get out of the way real quick. So I'm going to introduce you to our speaker. It is my pleasure to introduce you to L.D. Thomas, a Dallas-based estate planning attorney, community advocate, and the founder of L.D. Thomas Law Firm, recognized multiple times in the Dallas Weekly as the best law firm in Dallas, y'all. L.D. is one of 20 attorneys selected to the 2024-2025 State Bar of Texas leadership class and a member of the Texas Bar Foundation, an honor held by less than 1/3 of 1% of the attorneys statewide. Beyond his accolades, LD has dedicated his career to service, providing free estate planning and legacy protection workshops to churches, community organizations, and families across Texas. His partnership with the Empower series has made complex legal terms simple, practical, and accessible to everyone. So please join me in welcoming a true advocate for legacy, community, and empowerment, L.D. Thomas.
Thank you so much.
Oh man, let's do the
Yeah.
Let's do the baton pass real quick.
All right.
Then put this someplace safe.
I think we're good to go.
And we are about to be blessed, my brother.
I appreciate it. Hold on. You said someplace safe. All right. I think we're good. Are we
All
still
right.
good? All right.
All right, man.
I appreciate it.
Thanks,
Thank you. Thank you. Thank you for that wonderful, wonderful introduction. I do a lot of these presentations, and I give a lot of information. Hopefully, I motivate a lot of people to think about estate planning and putting that together. But one of the unintended benefits of doing these is you get to hear people like Clifton say wonderful things about you. And so that's one of the reasons I get up early on a Saturday morning. But Clifton, I want to take just one moment. I know we have a jam-packed agenda, but I do want to take a moment to thank you, not only for the invitation, but I want to thank you for all of the work that you have done over the years with Empower Series. You have blessed so many people, so many families with the information that you put out to the people. You, sir, are a true shining star. And I am blessed for being connected with you, and thank you for that. All right? So now that we know everybody is happy to be around everybody and everybody's doing great, let's dive right into some of the information. So yes, that's me, and we've already gone through the introduction. No need, even though, you know, talking about myself is probably one of my favorite topics. We're not going to spend too much time on that. But I will tell you just this little story about how I got involved in estate planning. Of all the areas in the law that exist, why estate planning? Why probate? I went to law school as probably a second or third career. I had been an educator. I'd worked in corporate America for a while. And I worked a full-time job, drove an hour down the tollway to go to law school for 3 or 4 hours a night, 4 or 5 nights a week. And God bless him, my estate planning professor, he's a wonderful man. He's actually a mentor of mine now. But he had a very black and white way of presenting. So you can just imagine having worked 8 hours, fought through Dallas traffic, sat through 2 other classes. By the time we started talking about your grandmama's China and your uncle's Chevy, I did not care, okay? I didn't care. I was just trying to get home. I graduated law school. I passed the bar on the first time, and I wanted to launch my career And I knew that I couldn't just quit my job immediately. I wanted to do something that allowed me to build up my practice. And I couldn't do criminal law because I felt like, well, if you got arrested and you needed me to come bail you out, the last thing you needed to hear was that I can't come because I'm in a marketing meeting. So I said, well, I'll try that estate planning thing, right? I can talk to people on the weekends and after hours. And it is honestly and truly a situation where I got into the field and the field got into me. It became a passion of mine. The more that I learned, not just surface level, but the deeper that I got into the importance of making sure that we all have our things together, the impact that it has on us financially, our families financially, but also those bonds of family that can either be brought together or torn apart for the lack of estate planning. It honestly became a passion of mine. So hopefully throughout today's presentation, you will see some of that, and you will know that I am not just doing this just to be doing it, but because it means that much to me. There's an old saying that people do not care how much you know until they know how much you care. And I do care very deeply about our community and about our community's well-being. This was already touched on. We don't need to talk about that. I will read this disclaimer. Please note that the information presented in this presentation is for educational purposes only and does not constitute legal advice. Now, while we strive to provide accurate and helpful information, we strongly encourage attendees to seek the guidance of qualified legal professionals for specific questions or concerns related to their individual circumstances. Well, LD, you are a lawyer. Aren't you qualified legal? I am very qualified. What I mean by that is do not take this information that I tell you today and think that you can now go past the bar and follow your questions. One of the things about the law, and even with estate planning, things will turn on a dime. So a lot of this information we're giving today is general. If we started getting into some probate issues and how things will play out, you need to sit down and consult with an attorney yourself, okay? What I hope to do today, and I think what our goal is to let you know the importance of taking these steps, getting the ball rolling. And we're going to give you some tools on how to do that. But I, as a legal professional, will always encourage you to sit down and speak with an attorney about these matters. And I will give you some examples on what happens sometimes when you don't, okay? So what we will do today, we'll go over the agenda. We're going to talk about why is estate planning important. We're going to lay a foundation. We're going to talk about some things that will hopefully spark a fire in you to say, you know what, I have been sitting on this far too long. Let me do something with that. Then we're going to cover the estate planning basics. I want to give you some building blocks and an understanding of some basic estate planning terms. For some of you, this may be a little remedial, but I want to make sure that everyone is on the same playing field. Then, thanks to our wonderful host, we have the AARP lesson book. That is a wonderful guide, and we're going to hit some highlights of that book. And it's a book and it's a tool that you can use to prepare yourself, to help you prepare your estate plan. And even if you decide, which I encourage you to do, to work with a legal professional such as myself, you can take that book, you can take that information, and it will make that consultation and make that process that much smoother. So thank you to Clifton and the Empower Series for providing that. And then we'll also go over one of the other documents that was provided, which is the record book. And as always, we'll leave room for questions. So I'm gonna need, because I can talk all day, all right? So give me a little bit of time, a little signal to make sure that we do leave time for that. Well, let's jump into that. Why is estate planning important? Why should I care what happens to my stuff when I'm gone? I'm not here. I'm halfway talking to these people in my family anyway. Why? I don't care. You should absolutely care. And let's talk about why that is. So I'm a numbers guy, so let's deal with some numbers first. The reality is 60% of Americans die without a will. I put that out there because sometimes when we have these conversations and we know that there are things that we should do, we know we need a will. We know we need something, right? We just know that that is the correct course of action that we should take. A lot of us put that off and we procrastinate. And sometimes the procrastination keeps us from moving. Procrastination turns into paralysis because we feel as if we're the outlier. 60% of Americans do not have a will. So if you do not have a will, you are not alone. You're not on the right side of that number, but you're not alone. It's okay. Take the steps to move into the other category. Now, over the last century, 3.8 million acres of land was lost due to improper estate planning. That equated to $6 billion with a B. One of the careers that I had prior to going into estate planning and the legal profession, I was a realtor. There is a common phrase in real estate as well. God is not making any more land. That is why land and real estate constantly increases in value. For a lot of us in the Black community and rural community, and especially here in Texas, land is king. We have a lot of our wealth tied up in land, which means we have lost a lot of our wealth because we didn't do proper estate planning. Now, our forefathers and foremothers, they did the best that they could. They didn't have conversations about wills and trusts. We are in a different time. Information is accessible. You got this handsome lawyer standing up here Saturday morning telling you this information. You don't have that same excuse. I want to pose a question. I have two numbers here. 19,800. Does anybody know the significance of that number? 19,000. I'm going to pick on you because you're sitting right here in front. 19,800. What do you think the significance of that number is?
The average amount of money that a family might have to leave.
They might have to leave. That's an excellent answer. It's a wrong answer, but it's a good answer. It's a good answer. So I'm going to tell you what that is. I'm going to take the heat off of you for a minute. A lot of people come to me and they say, well, okay, I know I should have a will, but I don't really have a lot of stuff, okay? I don't really have a lot of money. I got my car, I got my house, so on and so forth. There was a survey done, and the average answer of what people considered life-changing money was $19,800. People said if I got less than $20,000, my life would change. So I say that to say, and I put that number up there because it may not seem like a lot to you, but to the person you're leaving it to, it could mean the entire world. The number next to that is $5,000. The average, the millennials that answered that question said if they got $5,000, it could change their life. So don't underestimate the impact that you can have on someone's life when you properly transfer those assets. And the other thing that I tell people when they say, well, I don't have a lot, LD, I don't really have a lot of stuff to give. I have worked with clients from modest estates, okay, to what we call taxable estates. And those are estates that are over $13 million. And I will tell you, those people with modest estates, you probably need an estate plan more than they do for different reasons because you and your family don't have the money to play with. I have had families come to me trying to get a couple of $1,000s out of the bank, and they desperately needed that. But the cost of hiring an attorney and going through that process to get that money out of the bank was more than the money that was in the bank. But there are some things and some steps and some tools that we can implement that would have allowed that money to be transferred. But you have to be proactive. So telling me, I just got my car, my apartment, that is not an excuse to not move forward. All right, so what are the benefits of estate planning? All right, sounds good. Okay. Number one, you are in control. I love sayings. I love quotes. You probably hear 5 or 6 more from me by the time that we are done. But there is a very true saying in my area of practice that if you do not have a plan for your stuff, the state of Texas has a plan, and you probably will not like it. I use this example because it hits home for a lot of people, especially when we talk about blended families. This is 2025. People on second, third marriages, we've got kids, we've got stepchildren, we've got bonus babies, whatever you want to call them. There is a common misconception about how community property would work in that situation. So Texas is what we call a community property state. So if you're married and you buy a home, for example, it's community property. People assume that if I pass away or if my spouse passes away and we purchase this home together, then the home is mine, right? We bought it together, it's community property. That is not always the case. It depends on your family makeup. If you are a blended family, if there are children outside of that union, be them before the marriage, after the marriage, however, if there are children outside of that union that belong to the person who has passed away, the surviving spouse maintains their 50% interest. The 50% interest of the decedent will go to the children. That is not how most people want that to go. But that is how the state of Texas, that's the plan that the state of Texas has for you. That creates a very interesting scenario quite a few times. So that means that the surviving spouse now owns half the home with her stepchildren. And sometimes those children are minors that may be younger than the marriage. So you could end up in a situation that you own half the house, the other half of the house is owned by your spouse's outside child who's a minor, which means their interest is then governed by their guardian parent, which would be the other person. That's a lot of mess. That can be avoided very easily by simply having a will or a trust or having a plan in place. These things don't happen by osmosis. You have to put that on paper and make sure that it's properly drafted and properly executed. It allows you to make provisions for loved ones. Again, our family structures look so different these days. There are scenarios where you may be closer to your stepchildren than you are your biological children. The law does not make provisions for stepchildren, right? So if you don't put it on paper, as Ann Nesby said, y'all remember that song, Put It on Paper? That's just me, okay. I'm telling my age. But if you don't put it on paper, there's no provision for them. And so even if you do have a close relationship with your own children and you raised your stepchildren since they were 2 and you want to make sure that they are cared for as well, you need to do that. Also, some of our loved ones come with different situations. Maybe they have special needs or they are, have substance abuse issues. There are ways that you can put certain trust into place so people can manage that for them. But again, that doesn't happen automatically. The state of Texas is not going through all of that for you. You need to do that. You need to take responsibility for your legacy and your folk and your people and make sure that your assets are divided and dispersed the way that you want in a way that's beneficial to them. Cost savings. So there is a understanding that probate, I want to avoid probate. Probate's expensive. Probate's expensive. Here's the reality, okay? Whether or not a person passes away with or without a will will provide their family with two different experiences, okay? If you have a will that's properly drafted, properly executed, yes, you do have to go to court. But typically that is a very smooth process that we can get done in a couple of, at maybe 2 weeks, if everything is clean, 2 months, if everything is as it should be, okay? You have to go to probate court for that. Now, if you do not, if your person passes away without a will, that is a long, protracted process, and we'll go into details about that. But that's a lot more expensive as well. So what happens a lot of times is the squeaky wheel gets the oil. When people go through that horrible process, it took 2 years and all this money, and it was drawn out, and we had to pay all these lawyer fees. That is often what they're talking about. So depending on your situation, a will may be the best thing for you, or we can talk about a trust. And we'll talk about some of the things that you need to consider to determine whether or not a trust or a will is best for you. But not having anything is the absolute worst thing possible, okay? Because it will drive up cost. Yes?
So, quick question, just to insert this. Jonathan Ortiz asked a question prior, way back.
Okay.
Where does a prenup fall into play? Does it solve any of these issues?
It does.
So,
Yes. So I will repeat the question. So the question was about a prenup and whether or not a prenup helps address any of these issues. And I'm glad that that question was asked. One thing people don't realize that I tell them is that a prenup, I consider that part of estate planning. So a prenup really comes into place a lot of times with a divorce and settling assets. However, it works in conjunction with your will. And so when we draft a prenup and I try to make sure that they are drafting their wills at the same time, because they'll work in conjunction and say, hey, if something happens, because the prenup is a contractual agreement that you do prior to marriage, but it also helps in cutting down cost in divorce, separation, and all of those different things that happen in life. So it helps save with those costs as well. Now, whereas a will and a trust come in and are kicked in due because of death, a prenup comes in at the separation or dissolution of a marriage. But they all kind of work together to make sure that there's an understanding of what should happen in those situations. But I do consider a prenuptial agreement part of estate planning, and I will go into this later because estate planning is not just what happens when you die. There are a lot of things that happen while you are on this side of heaven that need to be taken into consideration, okay? Excellent question. Taxes, if you have a taxable estate, if your estate is over $13 million, anything above that is right now subject to a 40% tax from the federal government. There are things and tools that we can put into place to minimize that. But again, those things just don't happen. You have to pick up the ball, start dribbling, and get to the goal line, okay? Plan for end-of-life care. Do you want to remain in your home? Do you want to go into a nursing home? Do you plan on getting some government assistance for that? So when people go into nursing homes and they say, well, I remember MERP or Medicaid took grandma's house and all of those things. Say, well, I know if I put it in a trust, it'll go away. Well, you can't do that at the last minute because there's a 5-year look back. So we need to start having these conversations as early as possible. The other thing is, please do not wait until your daddy is mowing the roof to say that he needs a will or a trust. Making sure that people are competent and know what they're doing and are in their right mind is a bedrock for proper estate planning. So doing it while you feel good is the best course of action. Let's not wait till something tragic happens or we're in the hospital, because that opens the door for those things to be challenged. And I think this is pretty self-explanatory. It eliminates confusion and eases burden. I tell people, your family is going to miss you. They're going to remember you, but it is up to you how they remember you. Did you leave them a mess, or did you leave them a legacy? That's up to you. Having to go through court, pull out birth certificates, go through DNA tests and all of that, that's a lot while people are trying to grieve you and go through the process of giving you your final goodbyes and then put their life together, and then they've got to clean up your life. Don't do that. Just don't do it to anybody you love. It's not fair to them. And I just don't think that that's something that anybody would purposefully do if they really thought about it. So we're going to go over some estate planning basics. As I said, most people, when they hear estate planning, it's like, oh, what happens when I die? It's so much more than that. Estate planning primarily involves making arrangements for the transfer of your assets before and after death. So a thorough estate plan should include directives for your care due to incapacity. There are a number of things that can happen to you while you're still here. If you're in a car accident, who's going to make medical decisions for you? And I love giving these presentations and doing these consultations, because when I ask questions, it triggers an answer. And so people will say, well, I'm married, it'll be my spouse. Heaven forbid you and your spouse are in the car accident together and they're in operating room A and you're in operating room B. If you don't have a medical power of attorney, they're running around trying to figure out who to listen to. What a medical power of attorney does, it allows you to put a primary as well as a secondary. It just makes sense. And sometimes it's not even a tragic situation. Say you're on vacation in Jamaica and you need somebody to handle some business for you. If you have a durable, which is a financial power of attorney, it authorizes someone to be your agent and handle business on your behalf. These are just basic documents that every adult should have. Full stop. Guardianship and inheritance manager for minors. If you have minor children, this is probably one of the most difficult conversations to have with people, because nobody's going to raise your babies like you're going to raise them. And to have the thought that you might not be here is very difficult. But I will tell you, the peace of mind that these parents get once these documents are in place and we walk them through how to fill these things out. Working with an estate planning attorney is helpful in this, because we can tell you some things that you may not automatically know. The individual who is the guardian for your child's person and the individual who is the guardian for your child's finances or estate, they don't have to be the same person. And the reason this is important is because you may have a brother who is a financial whiz and who you know will take care of the money and invest it and make sure that your child will be financially sound for as long as possible, but he is also in the Dominican Republic and Vegas and Miami every other weekend. But you may have a sister who has the exact same moral compass, and you know she will raise your children the way that you would and give them the morals and values that are important to you, but finances, absolutely not. So, in that scenario, brother can be in charge of the finances, sister can be in charge of raising the children. But again, people don't know this until they sit down and have the conversation. So, one of the things that I hope to do today is to demystify all of this. It's not as scary as most people think. All right, provisions for family members with special needs. I touched on this earlier. If you have a family member who is receiving any type of financial-based government assistance, you want to put a special needs trust. It's called a S&T. And S&T stands for Special Needs Trust or supplemental needs trust. And I like to use the term supplemental needs trust because it really underscores how it works. The language in this supplemental needs trust simply says, we're going to use the government's money first, and whatever money we have over here in this trust that we set up for this person, we'll use that to supplement that. Otherwise, if that money is in that individual's name, it may disqualify them for that government assistance. These are things that you have to do. You have to push the button and get these things started. They don't automatically happen. And if there ever comes a situation where they are needed, I promise you, you're going to be so thankful that you took the time and energy to get it done. Life and disability insurance, we all know GoFundMe is not insurance, right? I don't sell insurance, but you have to have it. Life comes at us, and it comes at us fast. And if we're talking about assets and asset protection, you have to have insurance to continue to protect those things that you do have. Be it a medical emergency, be it anything. Brother, I can't. I got 5 minutes? 25. Oh, I got 25 minutes. Okay, thank you. Well, you know I can't see. All right. All right. So, and again, we touched on this attempt to minimize costs, taxes, and fees. This is important. Ongoing discussions. Ongoing discussions with the people that you have given these authorities to, right? If you have selected someone to be your power of attorney or your medical power of attorney or any of these authorities, let them know that. It'd probably be helpful if they knew that they were making these decisions. Also, let them know what your wishes are, how you would want them to operate and decisions you would want them to make. And if you have brought in your family on what your will says, let them know so that when the time comes, they're not surprised. Now, that's situational because some people might need to be surprised, right? So you're not obligated to tell them what's in your will beforehand. But in most situations and scenarios, if there's a good relationship with everyone, just let them know, hey, I have a will. You got this, you got that, and that's going to be that. So that everybody knows, and again, that protects and helps those bonds stay together during the time of grief. And ongoing discussions with your estate planning attorney. I will talk about this later, and the AARP book does a great job of pointing this out. When you have changes in life, be it a death of a loved one, buying a new home, grandbabies, whatever, marriages, divorce, that's an excellent time to review your estate plan, review your will, review your trust, because maybe what we said 5 years ago isn't applicable today. So it's not a silver bullet one and done, right? It's definitely, we need one for sure, but it's not a one and done. And so sometimes you'll have those discussions and it will say, you know what, actually everything's still good. This is operating the way that I want. Great. Other times it's very important that we make some adjustments. All right. Building blocks of estate planning, as I touched on, durable power of attorney. That's the financial power of attorney, the medical power of attorney. Beneficiary designations for your insurance policies, and there's some other tools that allow you to put beneficiaries. Anything with a beneficiary on it passes outside of probate. So it's a very powerful tool because if you have an insurance policy that pays out to someone, the money can go to them immediately. And that has been so helpful, especially if you are in a situation where you're living life and you're still paying a mortgage. When you pass away, that mortgage is still due the next month. The lights, if you have electricity in that home, all of your bills, well, not all of them, but the majority of them, especially those assets that you're wanting to pass on to someone, will still need to be paid. And so having insurance and making sure that the beneficiaries are properly updated will help make sure that those assets are protected during that time. Everybody's money is tight today, okay, in 2025. Everybody is feeling that. So imagine if one of your loved ones passed away and left you a house that they have a mortgage on. You're trying to pay your mortgage or your rent, and now you've got this up. That's a lot, okay? So we have to be mindful and have these conversations of not only who gets what, but how am I going to make sure that they care for it? Are they in a position to make sure that it's paid for? Guardianship. We talked about guardianship for minor children. I also want to talk about guardianship for yourself. There's a lot of people who don't understand that you can put into place a document that's called guardianship for the event of future incapacity, which says if I get dementia or if I have an accident and I need a guardian for myself, this is who I would prefer that to be. Because obviously in that situation, you won't be able to speak for yourself. It also allows you to say, under no circumstances should you ever put this fool over here in charge of me, okay? So you can say who you would like and who you would not like. It's an important document. Asset distribution, wills, and trust. We will talk about those in this section. So our host was so gracious to provide you guys with some really great information, starting with the AARP lesson book. It walks you through some of the steps and some of the most important steps on putting your estate plan together. Disclaimer from me, you need to talk to a lawyer, okay? I'm telling you right now. But this will give you the knowledge to walk into those consultations empowered to know what you're talking about, to use the terms, and also spark some questions. So I want to talk about some highlights because I went through the book as well. And I'll talk about some highlights that I think are important. So when putting your estate plan together, it talks about, in this book, it talks about putting a team together, the people to help assist you. Number one, we have an estate planning attorney. Shocker, right? I'm putting estate planning together. Probably should work with an estate planning attorney. But some of the other people, depending on the complexity of your estate, okay? So I will say everyone should probably at least start with an estate planning attorney. Not everybody will need a public accountant, but if you have assets and considerable assets, possibly. So don't let this list say, well, I don't feel like talking to all of these people. Don't let this list stop you. This is kind of a list depending on how big your estate is, okay? But an estate planning attorney, a certified public accountant, a certified financial planner, if you have assets and you have money that you're trying to invest and grow for sure. If you have a trust, we have a trust officer. We'll talk about that. And if you have enough money or if you have decided not to leave it to family members, or if you want to leave a portion to a charity, obviously a charitable gift planner as well. But again, you don't need all of these people. It's not, all of these people are not a requirement. It just depends on how much money you got, okay? But everybody should, I believe, start at least with an estate planning attorney. So if you turn to page 9 and 10 in the, which one is, this is the playbook, right? Yes. Okay, so 9 and 10 of the playbook. Let's talk about some of the steps in creating your will. These are some of the things that an estate planning attorney will walk you through, and these are some of the things that if you choose to go out there on your own and try to do this, these are the things that you will need. I do not recommend that. I will stop right here and pause right here. I cannot tell you the number of times that people say, well, you know, LD, I put my will together. This lady at the church came by and told me something. I kind of did it. Would you mind looking over for me? Sure. And every time there's something wrong. And it's something wrong that will drive the cost up 4, 5, 6 times, or even disqualify the entire will, okay? So the way that I would recommend you using this is to go through this, fill it out as much as you can, and then walk and talk to an estate planning attorney and have it all laid out, and then make sure everything is drafted and signed appropriately. But the first thing you need to figure out is who gets what and how. Who gets your stuff? Who do you want to have your house? Who do you want to have your car? Who do you want to have things that you don't even know that you have? One of the biggest pushbacks I get is, I don't have a lot of stuff. You do not know what you will be worth when you die. If there is a wrongful death lawsuit, if there is a negligence claim, if there is a lawsuit, you could be worth millions of dollars. A will can say, hey, well, this is who I would want to get that if it's properly drafted. So that's another thing about talking and working with an attorney. We will tell you the things that you don't even know to think about. But that's where we would start. Those are the things that you need to start contemplating. Who gets what, and how do they get it? Do you want someone to manage it for them? Do they have a substance abuse problem? If I give them $10,000, are they going to beat me to Laurel Ann, right? Like, is this the right way? So who gets what and how? Choose your executor. Now, that's a term that a lot of people may or may not be familiar with. The executor is the individual who is in charge of your estate and appointed by the court when you pass away. This person is given the authority to talk to banks, receive money, set up accounts, do all of that, and distribute your assets in accordance with your will. Two things I want to point out. Always have a backup. We don't know the order in which we're leaving here. And there have been many situations where someone put the executor and the executor predeceased them. And if you don't have an alternate, it creates a bottleneck, because now all of the people that you left something to have to get together and agree on who that executor is going to be. Choose a guardian for minor children. Now, this particular document, and this is where some of the stylistic choices kind of separate. This playbook here and some other attorneys put your guardianship for minor children in your will. If you work with me, that's going to be a separate document, okay? The reason I do guardianship for minor children separately is because those change a little bit more frequently, believe it or not, than your will. And so we can change this document. You know, your best friend was supposed to watch your kids, or something happened to you, now you're mad at her. Okay, well, now it's going to be my sister. However you want to do that. So those documents change more frequently, and it's a lot easier to change them than trying to change your whole will. But the point here is you need to make those decisions. Whether you put it in your will or whether you put it in a separate document, these are the decisions that you have to talk through and think through when coming up with your estate plan, and then finalizing your will. It has to be, I said this earlier, it needs to be properly drafted and properly signed. That means a will does not have to be notarized. But a self-proving affidavit does have to be notarized. And I will stand up here and tell you that if you cannot explain to me why that is and what that means, you need to work with an attorney. You don't need to be doing this by yourself. Now, you can go through this book and fill out as much information and then walk into the attorney's office and be extremely prepared, okay? But those are differences that do make a difference. So making sure that you have the proper witnesses. If you leave something to someone in a will, he's like, hey, you know, I did my will, why don't you come over and sign it for me? Depending on that person's relationship with you, if you left them something in the will and they were a witness, you just crossed them out. Their gift is now null and void. And I've ran into that situation a few times with people. And think in mind, this person has taken time to come out and sign this and help you with this, and they thought they were getting something, and then they don't, okay? So you have to have disinterested witnesses. A self-proving affidavit is a document that the testimony that the witnesses would need to give in court, it's reduced to writing and notarized. That's why that one has to be notarized. There are so many nuances to making sure your will is properly executed and properly signed that it's just worth it. Because if it's not, I tell you, I have had cases, because this is the other thing. So I do estate planning and probate. Probate is once the person has passed away. So I get to see both sides of this. I have people who have come to me with wills and documents that have been drafted by other attorneys, and we try to get them through the court, and there are issues, or that they've done themselves. I've had situations where it's had to be split into two different cases because there's language that should be there that's not there, okay? As always, revisit your decisions every several years or upon a significant life event to make sure that the beneficiaries and the amounts you choose are in line with your current wishes. So I talked about that earlier. It's important under those major life events to have those conversations with your estate planning attorney. All right, so page 13. What's a trust? And I get this a lot. What's a trust? What's the difference between a will and a trust? In essence, a trust is a management agreement. It is a document that's set up that allows you to transfer assets into it. It manages assets for the benefit of someone else, okay? There are three major roles in a trust. And I say roles because these three roles can be one person, they can all be the same person, or they can be three different people. Number one is a settlor. That's the person who sets it up. So if you come to me and you say, LD, I want to set up a trust, you're the settlor. The second is the trustee. The trustee is the person who manages the assets. They have the authority to manage whatever assets have now been transferred into the trust. And then the third is the beneficiary, the individual or individuals who benefit from the trust. So we have the person that sets it up, the person that manages it, and the person that benefits from it. You can set this up, you can manage it, and you can benefit from it yourself. You can set it up, you can have your cousin manage it, and your kids can benefit from it. So that's what I mean when I say there are three different roles, but they can either be three different people, two different people, or one, or all be the same person. What's important to know about a trust is it is a two-step process for the most part. You have to establish it. You have to go through all the terms. You have to set it up, and then you have to fund it. You have to transfer your assets into the trust. Okay, no. You have to transfer your assets into the trust. A trust only has control and dominion over those assets that are inside of it. What does that mean, LD? That means if you have a house, we need to do a deed and transfer the deed out of your name into the trust's name. It only controls what's in its name. If you do not, it's not inside the trust, okay? A lot of people, I use Michael Jackson as an example. Celebrities are like, well, how of all, how do these celebrities have all these things and not have anything in place? Michael Jackson had a trust. The issue was he never transferred anything into the trust. So it's as if they didn't have anything. So having a trust is only one part. In my practice, I've had families come to me, grandmama or grandpa ordered a trust off of TV back in 1988, and they've got this big thing, and true enough, they have it. We go to look at it, never transfer the house into the trust. Trust is not in control of that. That's how important this is, okay? And that's why it's important to work with an attorney to tell you how all of this works. Because it's one thing to get it, but making sure that it works the way that you want it to work and expect it to work, that's really the key. All right, so there are many types of trust, but there are two main categories of a trust. And especially with social media, everybody and their mama and their cousin is telling you, go get a trust. Trust is the way to go. Don't go to probate. Trust. I am going to tell you what God loves, and that's the unadulterated truth. Number one, there are some people who are pushing that because it costs more, and so they make more, okay? The information that they're telling you is accurate, but it may not be applicable to you. So they're not necessarily lying. Yes, a trust does help avoid probate, but there are other tools at your disposal, depending upon your assets, that can help minimize the likelihood of going through probate, okay? But they're not as expensive as a trust. But my point here on this slide, that there are two categories of trust. There are many types, but two categories. And you have a revocable trust and an irrevocable trust. So with the revocable trust, it is what it says. You can revoke it. You can shut it down. You can build it up. I revoke it. You can shut the whole thing down, take everything out of it. You can change it. You can modify it. You can change the beneficiaries. You maintain so much control. You're tied to that trust. Now, with the irrevocable trust, it's just like it says. It's extremely difficult to change it. You set it up, and it is expected that this trust is to remain ironclad. You will need to get court orders and beneficiaries and everybody to sign off to make those adjustments. Okay. Now, what's the difference? What's the benefit? When you hear someone say you need an irrevocable trust to protect your house, here's what they're not telling you. With an irrevocable trust, because you can't change it, because you're severing so much control, if you still have a mortgage on that home, if you're still paying a note, that typically triggers the due on sale clause, which means it's as if you just sold that house because you're not in control of it anymore. So you need to pay your balance. And for a lot of people, that's not practical, okay? Now, with a revocable trust, you can transfer, especially if the language is in there appropriately, you can put your home in the trust. You can still pass that asset to whomever you choose without going through probate, okay? Now, there are protections that you don't get because you are still in control of it. You are still tied to it. But there's flexibility that you do get. So that's why it's important to sit down and take the information that you've been given online or that you've heard and see, number one, is it accurate? But also, most importantly, is it applicable to you in your situation? These are called estate plans for a reason, because they're plans. Everyone's assets, everyone's family, everyone's goals are different. So everyone's plan to address those things need to be different. It's not a one-size-fits-all type of scenario. All right, so the record book, which is the other document that was provided for you, it's an excellent tool. If you go through that, it is, in essence, when I looked at it, I saw it as probably one of the most robust intake forms I've ever seen. If you take the time to go through that, fill that out, work through the questions that you can, and then meet with an estate planning attorney with that, the process of getting your stuff set up will be so smooth, and you will be their favorite client, right? Because this particular document does ask you a lot of questions. It asks you to categorize some assets. It asks you to make decisions. What I want to make sure you understand, though, as thorough as this document is, because it does ask you, well, who do you want to get your stuff? Who do you want to do this and the third? This is not a will. You cannot fill this out and think you're done. Just because you typed this in, that's not going to hold up in court, okay? This is a tool. This is a means to an end, but it is a great tool. It is a fantastic tool because it does ask some really important questions. And speaking of questions, do we have time for questions?
Yeah, you do.
Okay, wonderful.
So first off, thank you. Give them some love. So, do you have any questions? If you do, just shout them out. We don't have a mic to pass around, so LD will just repeat it so that people who are watching. And I have some questions here too. So
Let's go.
if you have any questions, fire away.
Yes.
Ooh, LD,
Oh.
I want to say Clifton's introduction of you didn't do you true justice.
Oh, that's so nice
I'm
of you.
just saying. I'm 69. I have a revocable trust, right?
Mm-hmm.
And I've been to a lot of these sessions getting to this point, and I learned a lot, and I want to know if I have my stuff and I want somebody else, want you to take a look at what I have.
Mm-hmm.
What does that take? I mean, I could call you, set up an appointment, et cetera, et cetera.
Mm-hmm.
And then, like, how much money can I expect to have to pay for
Have to pay for that. Okay.
So you got to repeat the fact
Oh,
that
yeah.
introduction.
Oh, no, I'm repeating all of that. Yeah. So for those of you who did not hear, she said that I did a phenomenal job, that she has been to hundreds of these, and I'm the best that she has ever heard, and that she learned so much from me. Yes, so I think that was the key of what you said. But no, thank you for that. But the crux of her question was, hey, you have a revocable trust, and you would like someone to review that, and how much does that cost, and what's that process? So I'm going to change it. So here's my contact information. So let's start there. So the number to my office is 945-235-2868. My email address directly to me is ld@ldthomaslaw.com. So if you want to set up a consultation for any reason, send us an email or call us. Quickest way is probably email because I check my emails constantly. So overall question, call us, say, hey, I have something in place. I need to have it reviewed to make sure that it is accurate and still reflects my wishes. Set up a consultation. How much it will cost depends. Reviewing trust, because I would imagine, how many pages is your trust? 30, 40, 50 pages?
No, it's not as much. You know, my millions of dollars, not all dropped into. So
Well, call us, provide us with the documents that you have, and we can give you a quote on that. What I will say is for those individuals who are watching us today and who are here today, because of the great work that Clifton has done, because of the Empower series, we're offering free consultations if you tell us that you were here and that you registered today. So it's a free virtual consultation, but you will need to email me, tell me you were here or that you registered, and we will need to set that up and make that happen before the end of this month. Okay?
thank you.
You're very welcome. Very welcome.
One more point. The point that you made about don't leave stuff. Don't leave this stuff, for your folk behind you to deal with. That's something that my now 40-year-old son said to me probably 20 years ago. He's like, Mom, y'all are educated enough.
Yeah.
Don't leave me with a mess.
Yeah.
Now, I didn't do it, that day or the next week or 10 years down.
But it planted a seed for you to do that. So just so you guys can hear what she says, and then we'll take, because I know you did have a question as well. Thank you for that. And that's important because I get this often from younger generations who say, I got my stuff together, but my parents don't want to do it. They don't want to deal with it. How do I spark that conversation? Just like your son did. She gave a wonderful story about how her son went to her and said, Mom, don't leave me with this mess. Just don't, right? And that's what I would encourage you to do. One, make sure your stuff is together so you can walk through the process, demystify it for not only your children, but sometimes for your older generation parents. Say, hey, I did my will. It's really not that bad. You really need to do it. But also tell them, hey, if you love me, do not leave me here to deal with all them fools on your stuff. Please don't do that to me. And so sometimes, like you say, it may not happen immediately, but that it plants a great seed. Thank you for that. Do you have a question?
Yeah, it was about this space. I was just curious to know if you were interested in setting up an estate. And you have, say, multiple assets, do you have to put all your assets in the trust?
Mm-hmm.
Something be here, and they say, I want this a certain amount of my assets in the trust.
That is an excellent question, and I'm glad you asked that. So the question was, if I want to set up an estate and I want to use a trust as part of my estate planning, my estate plan, do I have to put all of my assets into the trust, or can I say some assets go into the trust and others do not? Is that a good summary of the question? So that's an excellent question, and it allows me to tell you how trusts work. So the answer is it depends. What I recommend, if you are going to use a trust as your primary estate planning document, that you try your best to put everything in the trust, okay? Because the trust is we're going to go through all this work to say who gets what percentages, who's going to manage it, and all of that, okay? And a lot of people try to use a trust, or one of the benefits that they try to get from using a trust is to avoid probate. So if the asset is not in the trust, and it's a titled asset, you will have to go through, more than likely have to go through probate for those assets that are not. So we'd have to have a really good reason as to why are we not putting this asset in the trust. And if you say, well, I want it to go to this particular person over here and I want the trust to be just for my family, then okay. And then there's a way that we can handle that particular asset. So generally, I do recommend that everything goes into the trust, but if you have a specific reason for a couple of assets to stay out, then we can look at that and we can come up with a plan to do that. The other point I want to make while we're here is a trust does not eliminate the need for a will. It creates a need for a special type of will, which is called a pour-over will. So, like I said, with the trust, it only controls what you put into it, right? So if you put it into there, it won't have to go through probate if it's in the trust. Try as we might, we very rarely know absolutely everything that is going to be in our name when we pass away. So we have a catch-all that's called a pour-over will. So if there's something that you didn't know was in your name and you didn't move it to the trust, or ended up in your name and you didn't know or you didn't have time to put it into the trust, the pour-over will says, hey, if there's anything out there, go ahead and pour it over into the trust. So it's a companion document to make sure that everything is covered. Because if you own a piece of land or you inherited a piece of property that you didn't know about and you didn't know to transfer it in there, then you're going to have to go through probate. And if you don't have that type of will, your family or loved ones will have to go through the type of probate for someone who did not have anything in place. So it's a companion type document. So I hope that answers your question. There was a lot of different scenarios, but okay. Any other questions? Oh, yes.
Regarding the revocable and irrevocable trust, you mentioned that you said there were some liabilities. I know they're different. What are the liabilities in that revocable trust? So if you have a revocable trust, you mentioned it
Okay.
doesn't protect you as much, and so there's some liabilities.
Correct.
What are those liabilities that you're referring to?
So when people come to me about trust, a lot of times, especially when they hear things online, and say, hey, I want to, what's the phrase now? Control everything and own nothing and take things out of my name and do that, right? So tax liens and all of those types of liabilities that happen in life for the most part. A lot of times when they are seeking those types of protections and they're trying to insulate their assets, that comes with an irrevocable trust. A lot of those provisions, because you are still so tied to the trust, are not available in a revocable trust. So with an irrevocable trust, you have to get a whole tax ID number. There's there's separate tax filings specific to the irrevocable trust. With the revocable trust, it's still tied to your Social Security number for the most part. Also, when I have clients who have different businesses, we have to go through this thing of re-education. It's like, hey, I don't ever want to be found. I don't want anybody to know. Like, even if I put my business in the trust, don't know me, this, that, and the third. In the state of Texas, if your business is registered in the state of Texas with the secretary, they're going to find you, right? Now, there are certain things that we can do to try to insulate that. There are some series, LLCs, all these types of things. But this notion of being completely anonymous is extremely difficult here. If you want to re-register in other states, that's fine. But to answer your question specifically, the shield that comes from separating yourself from those assets with an irrevocable trust, a lot of those are not available with the revocable trust. We have any questions online? Clifton?
Yeah. What happens if someone? Okay, you already answered that one. There's another one, can you touch on what probate is exactly? So what is probate exactly?
That's a great question.
That's from Aquila.
So the question was, what is probate? What we hear this word all the time. What is probate? Probate is the process in which titled assets are changed via the courts. Okay? So when we say probate, that can look differently depending on your situation, whether you have a will or not. You still go through probate court. I don't think I illustrated this. The stark difference of someone passing away with a will and without a will. If you pass away with the will, you go to probate court, present the will. If it was right, done appropriately, signed appropriately, the judge looks at it, say, hey, ask a couple of questions. Were they in their right mind? Is this you? Do you accept? And we move on. If a person passes away without a will in the state of Texas, it's a two-step process. The first part is called determination of heirship, right? We're familiar with this concept that the heirs get something. If they're kids, they should get something. The wife or husband should get something. Well, the state of Texas and the courts just don't take your word for it, right? You have to prove that you're an heir. So that's the determination of heirship. You have to file an application, say they were married, they were not married, they had children, whatever that is. And then you have to get two witnesses to come in to court and attest to that. And then the court also appoints another attorney to go out and do their own investigation to make sure that y'all not lying. You're paying for all of that. And that's just the first part. So once you go through all of that, and then the court says, okay, those are the heirs, now the heirs have to determine who's going to be the administrator. So we said executor. If you guys remember that, we talked about the term executor. Executor is when you have a will. That role is called administrator when you don't have a will. So they can kind of do the same thing. They're the person that's in charge of divvying up the assets. All of the heirs have to agree on who that person's going to be. My family can't agree on who's making the macaroni and cheese on Thanksgiving, let alone who's going to be in charge of all these dead people's stuff, right? And so that's where a bottleneck happens a lot. That is where a lot of the costs go up a lot. Also, I want to go back to proving heirship. If the person who passed away is a male and they have children, you have to ask yourself, did they sign the birth certificate? Were they married to mom? You have to go that deep. You just can't go and say, yeah, that was his kid. You literally have to prove it. That too can cause a problem. That's how we get into DNA testing. That's how we get into, in some situations, having to exhume bodies to get DNA evidence. All of that can be avoided if we do what? Get a will or get a trust. Get something on paper.
It almost sounds like it should be a mandatory practice. You can't move on in life without having it.
You know, I agree, but I will tell you, there are people who benefit from our lack of knowledge and our lack of not motivate. There are investors out there. There are industries out there built on people letting their assets go. How many of you are familiar with the great wealth transfer? So the concept is that in the next 20 years, there's like, I think about $3 trillion that, don't quote me on that, the number, there's a lot of money, okay, that is expected to be passed from the boomer generation to the millennial generation and Generation X, okay? What I tell people is the money is going to transfer. Now, whether or not it transfers to your family is one thing. When I started this presentation, I talked about, I think there was, what was the number? It was billions of dollars worth of land that was lost in the last century due to improper estate planning. It was lost to the families. It was not lost to investors. It was not lost to the government. So the money is going to go somewhere. And there are, unfortunately, people who benefit from us not doing that, and that's one of the reasons that's not mandatory.
So I got two questions, and we might have to wrap it up pretty soon. So one is from Linda. She's a real estate agent. She says, how is homestead exemption impacted if home goes into a trust?
So if it is in a okay, I'm sorry, thank you. So the question was about the homestead exemption and how that's impacted if you put your property into a trust. That is another reason to make sure that you are using a revocable trust. There's certain language that you need to make sure is in there so that the taxing authority will recognize any type of homestead exemptions or senior citizen tax exemptions or even veterans tax exemptions, any type of property tax exemptions that you have. In a revocable trust, that language is there because, again, it's still so closely tied to you. That language is there, they'll go ahead and recognize that, okay? With the irrevocable trust, you do run the risk of losing some of that, okay? When people ask me, well, LD, do I need a revocable trust or irrevocable trust? There are a couple of things that we look at. With an irrevocable trust, think of it as you are putting something in a safe that you will never need to touch again. You are leaving this for somebody else, all right? So if you had $500,000 or a house or whatever you wanted to put in a trust, will you ever need, is there any chance that you will need to touch this ever again in life? If the answer is, well, yeah, possibly, then that's not for you, okay? An irrevocable trust, for the most part, is for money and assets that you are already trying to separate and pare down because you got so much over here, okay? There's some other uses for it. For people with taxable estates, we can put insurance policies in there to pay for their taxable exposure. But again, those are people whose estate's over $13 million. So again, we have to look at your situation and see where we are and what makes sense. You have a question?
Yeah, this may be implied in the explanation, but for clarity, can you have more than one trust?
Yes.
So you can't have an irrevocable trust and then
Irrevocable.
revocable.
Absolutely.
Assets you definitely want to still have access to, and things that, you know, hey, we're not touching that if you're in
Yeah.
your name. Okay.
Yeah, so you can have an irrevocable trust. There are a number of scenarios that I can think of where multiple trusts come into play. Probably the most common that I do is we'll have someone who wants to do a revocable trust for their estate planning, and then they have a loved one who needs a supplemental needs trust because that supplemental needs trust is tied to that individual. So right then and there, we've got two trusts that we need to set up. So, but there are a number of reasons, ways, and scenarios where we need multiple trusts.
Okay, another question was, how do I handle real estate that's in another state?
So the question, that's an excellent question. The question is, how do I handle real estate that is in another state? That is a wonderful situation that would make sense to have a trust. Real estate has to go through probate in the state in which it exists. So if you have property in Texas, California, and Florida, even if you had a will, your family has to go through probate in Texas, California, and Florida. So that's 3 different probate cases, unless you have a trust. If you have a trust, you can transfer all of those assets in all of those different states, all those different properties into that trust. And like we said, if they're in the trust, you don't have to go through probate for them. We typically get an attorney that's licensed in whatever state just to review the deed to make sure that it's compliant with that and then transfer it into the trust. But that is an excellent question. And multiple properties in multiple states is a scenario in which it starts to make financial sense for people to have a revocable trust.
And then another question is, what is the most likely asset that people forget to put into their trust?
The question is, what asset do people most likely forget to put into the trust? You know, I've seen different scenarios. I don't know if there's one common thing. Like I said, people have inherited things that they didn't know were in their name, so they didn't know to put it in their trust. People have been in the middle of a lawsuit. So that's another thing. If you're in the middle of a lawsuit and you pass away, a lot of times, if that lawsuit ends up being successful, that is written out to the estate because you're not here to put it into the trust. So, you know, there are scenarios that don't allow people the opportunity to put things in trust or things they didn't know that they've inherited. I mean, even if you just go to Texas unclaimed money, there's billions of dollars there that people don't even realize that they have. You know, so there are a number. I don't think there's just one thing in particular that people forget to put into trust. It just happens.
Okay, so we're about to wrap, but what you got to do before I go up there is you got to tell everybody how to stay in touch with you because,
Okay.
and kind of summarize this. In every program, I want to provide hope that people can realize what they envision. I want them to be inspired to take action. So I created this action guide. We talked about the RRP pieces. So have them take
Yes.
even calling you.
Yes.
You've educated us. You've given us information that people didn't know before. There's a lot of comments going on online that I couldn't get to you.
That's okay.
And then lastly is connecting to resources, which you do.
I think so, yeah.
Hope, inspiration, education, and connection to resources. Summarize that up, and then I'll come up and I'll close everybody out.
That's all? No, thank you for that. Thank you for the opportunity, first of all, to do here. I give a lot. I'm not gonna lie. I mean, I give a lot of information, but I get so much more from this, right? Just knowing that people are walking out empowered. But to Clifton's point, education is one thing, empowerment is another, action is what's really important. So what I am going to ask is that you think about, like right now, like don't go home and think about it. Think about right now, 2 steps. I think he wants 1. 2 things that you can do to move the needle forward. I will tell you, one of them is setting up a consultation with me, okay? My contact information is on the screen. It's also in the presentation. I will say it again. My office number is 945-235-2868. My email address is ld@ldthomaslaw.com. You can also find us on Facebook, Instagram. Connect with us. I put out videos, I put out information, I put out little corny memes that I think are funny, right? But to keep these concepts and things in the forefront of your mind. Another thing you can do, another action you can take is absolutely start working on that workbook. Work through those questions. Think about those answers and do that. And thirdly, you didn't tell me to do this, but I want you, everyone who is online and who is here today, give yourselves a round of applause because this is Saturday morning. You guys decided to spend your Saturday morning here doing this. You talk about ahead of the curve. You guys are top notch, and thank you for this time. Thank you for your attention, and I really appreciate it. And thank you, Clifton, for the opportunity. You need my mic? All right.
Yo, 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 man, we are blessed. Give it up for LD again. Thank you, thank you, thank you, thank you. So time, don't we wish we had more time? I want to thank you for sticking in with us. This is longer than we anticipated, but like I said before on the chat, this is not the end, this is the beginning. I put a link out there, and all of you have this on your table, which is an action guide. I was telling LD that I want him to say that there's 4 things I want to get across in every workshop. I want you to have hope that whatever you envision, you can achieve, right? No matter where you are, whatever you envision is real. Your imagination is real. I want you to be inspired to take action, act on your ideas. So I want to encourage you to fill this out. Let us, write down what you're going to do. If you're so inclined, share that with me at thrive@empowerseries.com. But being inspired and not taking action doesn't really move you forward. So please, we hope that you are inspired. You definitely was educated. You got some new information today that you didn't know before. And then lastly, stay connected. So stay connected with the people in this room. Stay connected with the Empower series. I know one of the people in the live chat said, I just ran across this in my stream. There are no accidents. You're not here by accident, man. This is intentional. So stay connected. Our next program is November 15th. We're going to have Shatelia Riley Irving. That is Kyrie Irving's agent. She's going to share her story. She's done some phenomenal things. You'll find out more about that, but stay connected with us. I want to thank you again. And go to our website, www.empowerseries.com. You can find out about the next events. You can make a donation because we are a nonprofit. You can also text GIVE or donate to 214-225-6337, or go ahead and give a donation on YouTube because it takes money to put this on. But the most important thing is for you to get what you're supposed to get from the Empower series. So don't just sit there and say good and move on. Get what you're supposed to get from the Empower series, share it with somebody else, and let us know how we've impacted your life. So until we meet again, be empowered and inspired.